name is Bradley Eldridge, and my co-counsel is Caleb Meyer. We are in support of Mr. Newdown. The phrase "under God in the Pledge of Allegiance" is unconstitutional under all three prongs of the Lemon Test. I will present why the Lemon Test is reliable, as well why the first prong of the Lemon Test, secular purpose, is not upheld. My co-counsel, Mr. Meyer, will explain why the pledge is not upheld by the Constitution, according to the second and third prongs of the Lemon Test, secular effect and excessive entanglement, as well as explain why the pledge is not constitutional under the endorsement test. First, let me address one of my opponent's main points: the coercion test. The coercion test is not an effective test to use. It was created from Scalia's dissenting opinion, and it was a knee-jerk reaction with no constitutional basis. Furthermore, in this dissenting opinion, nobody else signed on to this opinion. Now I will explain why the Lemon Test is reliable. The Lemon Test
You're asserting that it's not a sufficient basis to, did Justice Scalia's opinion make sense? Just because it was a dissent, and it's not a lone dissent, doesn't mean that it didn't have logic, it wasn't supported by the history of the First Amendment. So what was the real problem with the coercion test, aside from that it was articulated by one justice?
Aside from that fact, I believe, Your Honor, that it has absolutely no constitutional basis, whereas the Lemon Test has constitutional basis, as well as the endorsement test. The Lemon Test was created as a three-part test designed to keep the government accountable to neither advance or inhibit religion. In other words, it keeps the government accountable in cases of religious entanglement. And it's even been historically accurate, or historically reliable, rather. The Lemon Test has been reliable for over 50 years. It's been used in many cases, and many that it is not used.
Counsel, how do we respond to the issue that's been raised by petitioner that the Lemon Test has been confusing, and that we've seen it applied, it can sometimes get applied differently in cases with similar facts. We know when it comes to school funding, particularly schools, it seems to be challenging to get applied. And so why are they wrong? It's an unworkable test.
Your Honor, I believe in many of those cases, in somewhere like Marsh versus Chambers, for instance, that the Lemon Test didn't have to be used, because this isn't the same case, obviously. And Marsh versus Chambers, it had to do with a legislative prayer, which is a tradition that's been used since the founding of the legislature. Whereas the phrase "under God in the Pledge" has been only in use since 1954, and the creation of the pledge was only in 1892.
Well, did you hear the bailiff call the court session?
Yes, Your Honor.
And wasn't there a reference to God in that?
Yes, Your Honor.
Is that unconstitutional? It's been done throughout the history of the Supreme Court.
I would argue that it's not unconstitutional, Your Honor.
Because it's been around for so long?
Partially because it's a tradition, yes.
And since 1954 is not a long enough tradition, isn't that when "under God" was inserted into the pledge?
I believe that it has been a violation of the Constitution when it was initially added to the pledge.
Counsel, do you think is there a difference with the fact that this is a public school case versus the example that Judge Murray just shared?
I do, Your Honor. I believe that when it comes to the point that we are forcing our religion on impressionable children, then that's one place where we should draw more of a line than in legislative prayer. And because that's not the government's place to be influencing kids in that way. And even before the Lemon Test was invented, courts have ruled prayers in school as unconstitutional, like in Engel versus Natal and Abington School District versus Shem. As well as Kitzmiller versus Dover and Edward versus Aguilar, both cases used the Lemon Test and successfully proved its reliability. In Kitzmiller versus Dover, the court set out to find whether or not intelligent design is a scientific teaching to be used in schools, and the ruling was that it endorses a religious view, therefore it's unconstitutional.
Counsel, the Lemon test indicates that if there is a valid secular purpose for the phraseology, and the other side argues that it promotes patriotism and kind of sets our country's values apart, not necessarily religious values, but our values. Is that not sufficient to get us past at least that part of the Lemon test?
Your Honor, I believe that this was a valid or an invalid religious purpose when the phrase "under God" was invented. They're not using they're using a specific monotheistic deity, and they're not.
I'm sorry, are you suggesting the Pledge of Allegiance even today is not instilling patriotism, or that isn't the purpose of it?
I believe that the phrase "under God" promotes a monotheistic deity when, in fact, there are many other religions in the United States that perhaps some are polytheists and some are atheists. We can look to Kitzmiller versus Dover in the case of secular purpose. The court ruled that intelligent design is a religious theory instead of a scientific one, cementing the fact that this is not an objective secular purpose, but a religious purpose in violation of the first prong of the Lemon test. This is a pertinent observation which can be applied to this current case because though they were not endorsing any specific deity, they were endorsing a monotheistic deity. While the idea of there being many gods or no God whatsoever is being discouraged, similar to the phrase "under God" in the pledge. This can even be seen in the statements released by the officials who passed the bill to include "under God" in the pledge. In 1954, President Eisenhower released a statement saying, "From this day forward, millions of our school children will daily proclaim in every city and town, every village and rural schoolhouse, the dedication of our nation and our people to the Almighty." Congress even released a statement in 1954 saying the inclusion of God in our pledge therefore would further acknowledge the dependence of our people.
Counsel, I'm wondering if you could expand more on this notion that monotheism is a religion. Obviously, we know the counterpoint to that being that that wasn't what the founders were intended. So I'm wondering what your response is.
Your Honor, I believe monotheism embraces a certain set of religions, whether that's Christianity, Judaism, Islam, which all are monotheistic.
Thank you.
And Congress released this statement, and these statements deliver a directly religious purpose and are encouraging an almighty monotheistic deity when many children and families may be discouraged to believe in a polytheistic religion as well as just atheism. The job of the First Amendment is not to force religion down the throats of its people, but to keep the government from impeding on people's personal beliefs.
But the First Amendment says that Congress will not establish a religion, right? Establishing a religion. How is this establishing a religion? It's just offending a few people who aren't religious.
Your Honor, it's not unconstitutional to simply acknowledge other or religions in general, but we believe that this phrase "under God" is endorsing this certain religion.
Endorsing but not establishing. Are those two different words?
There, Your Honor. But the First Amendment states that it doesn't make any law respecting Congress should make no law respecting the establishment of religion or prohibiting the free exercise thereof. Therefore, we believe that this is unconstitutional because it's forcing children to admit that this country and they are under the influence of a deity they very well may not be under the influence of. The phrase "under God" in the Pledge of Allegiance is unconstitutional under all three prongs of the Lemon test. I yield the balance of my time to my counsel.
Thank you.
I think all three of us probably agree that Holly did a fantastic job. And are you all what level of school?
I graduated.
Graduated.
18-ish, 19, okay.
I'm sorry?
I graduated high school as well.
Great.
Voted to see you here.
Okay, I mean, it's incredible that you can get up here. And I mean, we didn't hold back on our questions. I mean, we would ask the same questions, maybe a little bit more, but same questions to the lawyers. And you all stood strong. And I was terrible. I didn't have get too well. I came here, but I didn't get any of your teams. But you did a very good job. I could tell you knew the law well. You've got a very good tone of voice. You were just too nervous. And like when you got up on rebuttal, you started very strong. Coming out why lemon, we should get rid of it. And then I think you looked up and you got nervous again. And it's understandable. I mean, I can all tell you, even as lawyers, our first time in court, we were trembling. And you just graduated high school, so you should be very proud of yourself. Same thing, I think you said in Madison, you're in Madison. You're very good eye contact with us, which is important. You get a little feeling about who you are. And as Justice Welch said, you were very good listening to what's being asked, and then trying to address it. And that's obviously critical because, we always tell lawyers this, that argument is really time for the judges. It's not for the lawyers, because it's our time to ask questions, to find out what problems we have with your case. And so the answering, the back and forth is what's good, and you're very good at that. First, respondents, what I liked about you, when you got up there, right away you said, I'm going to tell you why they're wrong. And that's good. I mean, that catches your attention. Like, okay, let's hear it then. And you had very good reference to cases and answered questions about. And then I had a great deal that you were very good. I tried to get you some questions, and you came back. I'm still not sure I agree with what you came back with, but that's for writing the opinion, not for oral argument. And your eye contact was good with us, and you gave a very strong performance.
Well, just briefly, I've never sat on the bench. I've always been on that side of it. And one thing, I mean, there are some attorneys who never got anywhere near, I'm not talking about students, attorneys never get anywhere near appellate practice and having to go. So your experience today is remarkable in that regard. I was interested in one of the things I was thinking about was I was interested in the historical facet of the argument under the lemon test. But when you're in a situation like that, to try to regroup yourself, or when you get asked a tough question, oftentimes you want to get back to something that you know is your strong point. And I used to think, is there some way I can respond to the question that's over here by bringing something from on this side that was my strong point and work it in. And so that's just one way, and I sense maybe that's what you were trying to do in your responses, and I think that's good. But anyway, I was impressed with what I saw today, and I enjoyed it very much. First time I've done some trials here for Michigan Youth in Government, but this was the first appellate. It's very interesting.
Okay, and I think we're supposed to weigh in on who we think maybe won, like oral argument.
Not the merits.
So we consulted about this, and it was very, very close, but we did in the end on the arguments find for respondent. So, but really all of it was very close, and you did a fantastic job. So you should all be very, very proud of yourselves.
Sure. Congratulations.
Yes, congratulations.